Hey, this is Angela, and you're listening to the Study for the Bar in Your Car podcast. This is the podcast where we use AI to further our studies for the bar exam. So let me explain how it works in case you haven't listened to this before. So I am Angela. I am an LLM student. I have gathered all my notes for studying for the bar. These are all my law school notes, my bar study notes. I've thrown them all into AI, and I've had the AI use the information to do specific podcasts on the various topics that are covered for the bar. So you'll really be listening to a podcast within a podcast. And I have my two AI hosts who I've called Claude and Maud, and they bring you the material. And I think sometimes when you listen to two people talking through the material rather than one person droning on, that really helps. At least the way that I learn, it helps me. But the real reason why I've done this podcast has been actually quite selfish. The real reason is to help me get past the bar exam. If you get past the bar exam too, then that is a bonus, but I certainly hope you do pass. Now, I've been speaking on a few other episodes about my journey to take the bar exam, and I was last registered, or I guess I should say I wasn't registered. I was supposed to take the bar exam in Palau. And for the past 2 years, I've been planning this trip to Palau to take their bar exam because they only give their bar exam during the summer. So they've got no February bar exam. And as you know, if you've taken the bar exam or you are a lawyer in the US, bar exams are typically given twice a year. And in every state, they're given twice a year in February and July. In Puerto Rico, they have different dates. I think they're like November and March or something like that. But then there are also territories of the United States. So you can take the bar exam in Guam, the Northern Mariana Islands, the Virgin Islands, etc. And then there are these countries that are part of the compact trade agreement. So these are territories that were sort of part of the US at one point, or the US sort of looked after them. And they had a choice whether or not to go for independence or to become a territory. And so these countries became territories. So we're speaking about like a Palau and the Marshall Islands. So because Palau still has this free association with the US, they get their mail through the US mail. So, if you're ever trying to send any mail to Palau, you can just send it with a regular stamp and not have to add any postage to that. So they also have a legal system that is very much like our legal system because at one point, there's my phone, I should put it on silent. At one point, you know, their legal system was incorporated in ours in some way. So now they've got their own constitution, but their law is very much based on US law. But there are some differences there. I don't know all the differences, but I was very interested in taking the Palau bar exam because they have a cut score of 250. Plus, you also have to, there goes my phone again. Plus, you also have to pass the Palau bar exam or the Palau, there's like a Palau law bar exam. So, you know how New York State has, you take the bar exam and then they've got a separate exam just for New York State. Palau's the same, but they've put it within their bar exam. So, whereas many other places have, like UBE bar exams, the Palau exam is basically the UBE plus their country specific bar exam. And the Palau bar exam is sort of facilitated through the NCBE, which is very interesting because the other nations, such as the Marshall Islands, they're not through the NCBE. So when you have an exam that's through the NCBE, it you may be allowed to take parts of the exam or take the whole exam in other places and then transfer your score to Palau and vice versa, if the particular state allows. So I have been planning to take the Palau bar exam for ages, and then I received the bad news that I will not be allowed to take the plow bar exam. They said my waiver was denied. Now, I applied for a waiver to take the plow bar exam because I don't have a JD. I have an LLM and an LLB. So I'm a dual American British citizen. I got my first law degree in the UK, and then I got my second law degree in the US and my third law degree in the US. Technically, my third one hasn't been granted yet, but I finished all the coursework. I'm just waiting for my final grades, and I think I still have to pay a little bit of tuition, and then I'm done, done, done. So, anyhow, I was thinking I was going to be taking a specific bar exam, and that rug was pulled out from under me. So, now there's a plan B, and my plan B has now become my plan A, and that is to take the bar exam in the Marshall Islands. Now, the Marshall Islands bar exam is not regulated by the NCBE. So, even if I take the Marshall Islands bar exam and become an attorney that way, I will still need to take it again, and I'll probably take it again. I mean, I'm not sure where. I'm looking at all states, but as an LLM, it's really restrictive where you can take the bar exam if you're not already an attorney. If you are an attorney already, then you have more options. So one reason in taking the Marshall Islands bar exam is to give me more options where I can take the UBE. Anyhow, I will get into the whole saga of, why suddenly I'm not taking the plow bar exam, or the specifics why. The very basics of it is that they came back to me very late with some information. And when I say very late, like really 2 months before the bar exam, which is really, really late, especially if you've already started your bar courses, you've started studying, you've started your study plan, you've made travel arrangements. But I have to say, now that I've switched to my plan B to plan A, where I will be going to the Marshall Islands judiciary, who regulates their bar exam, they have been lovely. They've been nice. They've been polite. They helped me with my hotel reservations. I mean, can you even believe that? And if you haven't taken a bar exam yet, I don't know how many other jurisdictions are, but let's just say if you called up the DC bar, they're doing a favor just by answering the phones for you. I'm not sure they want to talk to anyone there, probably because they get a lot of phone calls, and probably because the way the DC bar is funded, I'm guessing they don't have as much money to staff there. So because DC isn't a state, it is it's a city within the U.S. Their funding comes directly from the federal government. Anyhow, we are going to get into it with Claude and Maud. So this podcast, this is episode 10. This is specifically about breach or remedies for contracts being breached. And it very much reminds me of my situation with Palau, in that if Palau says you are registered to take the bar exam, or if they say, okay, you are able to sit the bar exam, and based upon that, you go out and you get a plane ticket, are they liable for the cost of that ticket if they come back later and say, no, you can't take our bar exam? Probably not on a technical or legal. I feel like there is some promissory estoppel there. But, whatever, these things happen. One thing I've learned about the law is that sometimes there's just not a remedy for when you've suffered an injury, or when you've suffered some sort of or pain or affront. Sometimes you just have to move on. And that is what's really hard. Anyhow, without further ado, Claude and Maud, take it away.
Welcome to the Deep Dive. Today we're tackling a really fundamental part of contract law.
Absolutely. What happens when a deal goes south?
Exactly. We're looking at remedies using Angela's really detailed outlines as our guide here.
Fantastic set of notes, really.
Yeah. So our mission is to unpack how the law tries to fix things when a promise, a contractual promise, is broken. What were you supposed to get? What did you lose? And how does the system try to make it right?
It's all about trying to achieve fairness, essentially. And Angela's outlines start, quite rightly, with the core concept, the expectation interest.
Expectation interest. Okay, so this is about getting what you bargained for, putting you where you would have been if everything had gone smoothly.
Precisely that. Putting the non-breaching party in the financial position they expected from the completed contract.
Right. And Angela's notes break this down. First up, direct damages. These sound like the most obvious ones.
They are. They're the losses that flow immediately and necessarily from the breach itself.
Like the example in Angela's notes about the widgets.
Exactly. You contract to buy widgets for $100 each. The seller breaches.
Right.
You then have to scramble and buy the same widgets, but now they cost $120.
So the direct damage is that extra $20 per widget you had to pay.
Spot on. It's the direct cost of covering the broken promise.
Makes sense.
Hmm.
Then Angela's outlines mention incidental damages. What falls under that?
Well, these are the extra costs you rack up because of the breach while you're trying to sort things out.
So, like costs associated with finding that replacement widget seller.
Yeah, or maybe you had to pay for rush shipping to get those replacement widgets quickly because you needed them. That extra shipping cost, that could be incidental damage.
Okay, so direct is the core loss. Incidental is the cost of cleaning up the immediate mess.
Good way to put it.
Now the next one, consequential damages. Angela's notes suggest this is more complex. It depends on what the breaching party knew.
Yes, exactly. This is a big one. Consequential damages are less direct losses. They arise from the non-breaching party's specific circumstances.
And the key is?
The key is that the breaching party knew or should have known about these special circumstances when the contract was formed.
Okay, so you have to tell them.
Or it has to be reasonably obvious.
Huh.
Angela's outlines probably have that example about the big penalty.
Yeah, the $75,000 penalty. If the widgets weren't delivered on time for a separate major contract.
Right. If you told the widget seller, look, I need these by the 15th, otherwise I get hit with a $75K penalty on my other deal, and they understood that.
Then if they breach and you incur that penalty,
then that $75,000 could be a recoverable consequential damage because it was foreseeable to the seller at the time of contracting.
foreseeability, that seems critical. Angela's notes contrast this with, I think, a plumber example.
Ah, yes. The idea there is, say, a plumber's delay causes a homeowner to miss out on buying a discounted appliance.
Okay.
Is the plumber liable for the lost discount? Probably not.
Why not? It was a loss caused by the delay.
Because unless the homeowner specifically told the plumber, your work finishing on time is critical for me getting the specific time-limited appliance deal, the plumber had no reason to foresee that kind of loss. It's not a typical consequence of a plumbing delay.
Got it. So foreseeability at the time the contract is made is a huge limiter, especially for these consequential damages.
It absolutely is. And Angela's notes also likely mention that courts might still limit damages, even foreseeable ones, if they seem wildly disproportionate. Compensation, not a windfall.
Right, not punishment. Okay, so those are the types of expectation damages. But Angela's outlines then group some overarching limits: causation, certainty, and foreseeability. We've hit foreseeability hard. What about causation and certainty?
Well, causation is pretty straightforward, conceptually at least. The breach must actually cause the damages you're claiming.
No remote, unconnected losses.
Exactly. There needs to be a clear link.
Yeah.
And certainty means you have to prove your damages with reasonable certainty.
Meaning you need proof, like invoices or calculations?
Yes. You can't just pluck a number out of the air. It doesn't need to be mathematically precise down to the last cent, but you need enough evidence for the court to make a fair estimate.
And if there's doubt?
Angela's notes probably point out that courts often resolve reasonable doubts about the amount of damages against the party who actually breached the contract.
That seems fair. Okay, so cause, certainty, foreseeability, the big three limits.
Okay.
Now, Angela's notes move to something different. Liquidated damages. This is where the contract itself sets the damages.
Correct. A liquidated damages clause is where the parties agree, right up front in the contract, on a specific amount to be paid if a breach occurs.
Why would parties do that?
Well, it provides certainty. It can save a lot of time and expense later trying to prove actual damages, especially if those damages might be genuinely hard to calculate.
Sounds useful. But Angela's outlines draw a line between these and penalties, which aren't allowed.
That's the crucial distinction. For a liquidated damages clause to be enforceable, it needs to meet basically two tests. First was the amount A reasonable forecast of the likely harm caused by a breach. You look at it from the time the contract was made.
A genuine pre-estimate.
Exactly. And second, were the actual damages difficult to calculate accurately at that time?
And if the amount is, like, way too high?
If it looks less like compensation and more like it's designed to punish the breaching party, the court will likely say, nope, that's an unenforceable penalty. They won't enforce it.
So it can't just be a threat to force performance.
Right. It has to be tied to a reasonable estimate of actual loss.
Okay. Then Angela's outlines talk about limiting remedies within the contract. Can you actually sign away your right to certain damages?
You often can, yes. Parties can, and frequently do, include clauses that limit the types of damages available or cap the total amount recoverable.
Like saying, our liability is limited to the cost of the goods or something.
Precisely. Or excluding liability for consequential damages altogether.
But surely there are limits on that too. Can they always get away with it?
No, not always. Angela's notes would definitely cover unconscionability here.
Unconscionability, meaning just fundamentally unfair.
Essentially, yes. A court might refuse to enforce a limitation clause if it's hidden in tiny print, totally inconspicuous, or if the circumstances are such that one party had no real choice but to accept it.
Or if the limited remedy doesn't actually fix the problem.
That's another key point Angela likely includes if the limited remedy fails of its essential purpose. Like if the only remedy is repair, but the item is completely destroyed or can't possibly be repaired, that limited remedy might be disregarded.
And Angela's notes also mentioned a specific rule for consumer goods under the UCC.
Yes, under the Uniform Commercial Code, trying to limit consequential damages for personal injury caused by consumer goods is considered presumptively unconscionable. There's a strong public policy against letting sellers disclaim responsibility for physical harm caused by defective products.
That makes a lot of sense. Okay, next up in Angela's notes. The duty to mitigate or avoidable consequences. You can't just sit back and let losses mount.
Correct. This is a really important practical rule. If the other party breaches, you, the non-breaching party, have a duty to take reasonable steps to minimize your losses.
So, back to the widgets. If the seller breaches, I can't just wait 6 months while prices potentially go way up.
Exactly. You need to act reasonably promptly to find an alternative supplier. The breaching party isn't responsible for damages that you could have reasonably avoided by taking appropriate action.
It's about being proactive then.
It is. Reasonable effort is the standard.
All right. Now, Angela's outlines shift gears a bit to rescission and reformation. These sound more drastic, like changing the contract itself.
They are. Rescission is essentially canceling the contract. It undoes the deal.
Wiping the slate clean.
Pretty much. The aim is to put both parties back where they were before the contract was ever made. Angela's notes list grounds like mistake, misrepresentation, duress.
Things that mean there wasn't genuine agreement in the first place.
Often, yes. And for a mutual rescission, where both parties agree to cancel, Angela probably notes the contract usually needs to be still executory, meaning neither side has fully performed yet.
Okay, so rescission cancels. What's reformation?
Reformation doesn't cancel the contract. It fixes it. It's where a court rewrites the written document to reflect the parties' actual original agreement.
When would that happen?
Usually when there's been a mistake in writing down the terms, like a typo or accidentally leaving something out that both parties clearly agreed on.
So you need proof of the original agreement.
Strong proof. Angela's outlines would stress the need for clear and convincing evidence that there was a prior agreement and that the written version doesn't match it. Interestingly, as Angela notes, simple negligence in reading the contract doesn't automatically prevent reformation, but the evidence standard is high. It can also apply if someone misrepresented what the document actually said.
Okay, so rescission is undue, reformation is correct. Then Angela's notes cover specific performance and injunctions. These involve court orders.
Yes, these are equitable remedies, not just money. Specific performance is a court order telling the breaching party, you must do what you promised in the contract.
When would a court order that instead of just money damages?
Typically when money damages are inadequate, the classic case, as Angela's notes likely highlight, is real estate. Land is considered unique.
Right, you can't just buy an identical plot somewhere else.
Exactly. So the court might order the seller to go through with the sale. But as Angela also probably points out, courts almost never order specific performance for personal service contracts.
Like forcing a singer to perform.
Right. It raises issues of involuntary servitude and practical difficulties in supervising performance.
Okay. And an injunction. That's in order to stop doing something.
Yes. An injunction prohibits a party from taking a certain action. In contract law, it might be used to stop someone from breaching a non-compete agreement, for instance, or to prevent ongoing harm caused by a breach.
Got it. Do this versus don't do that. Now, Angela's notes also mention reliance and restitution interests as alternatives to expectation damages.
That's right. Sometimes calculating that expectation interest where you would have been is just too speculative or difficult.
So reliance damages are.
They aim to put you back in the position you were in before you relied on the contract. They compensate you for expenses you incurred because you trusted the other party's promise.
Like costs you spent preparing to perform your side of the deal.
Exactly. Money spent in reliance on the contract going forward.
And restitution, how is that different?
Restitution focuses on preventing unjust enrichment. It's about giving back the value of any benefit that one party conferred on the other.
So, getting back what you gave the other side.
Essentially, yes. It can be a remedy even if there wasn't a valid contract, like in quasi-contract, or after a contract is rescinded. It prevents one party from keeping a benefit they didn't fairly pay for or earn.
So reliance is about your expenses, restitution is about the other party's gain.
That's a good way to think about it.
Finally, Angela's notes cover something intriguing. Remedial rights of the breaching party. Even if you break the contract, you might get something back.
It might seem counterintuitive, but yes. It ties back to that idea of preventing unjust enrichment.
How does it work?
Well, imagine you partially performed a contract, say. You delivered half the goods, but then you materially breach, maybe by failing to deliver the rest. The other party terminates the contract.
Okay.
Now, the non-breaching party has the goods you delivered, but hasn't paid for that portion, perhaps. Angela's notes explain the breaching party might be able to recover in restitution for the reasonable value of the benefit you did confer.
But wait, minus the damages I caused by breaching.
Exactly. Minus the damages the non-breaching party suffered because of your breach. It prevents the non-breaching party from getting a complete windfall from your partial performance.
So it's not a reward for breaching, but it stops the other side from being unfairly enriched by the work you did do.
Precisely. It's about fairness, even in the context of a breach.
Wow, okay. Let's take a moment here. That was a lot, covering the whole landscape of remedies based on Angela's outlines.
It's a complex area, for sure.
Definitely. We went from the basic goal, the expectation interests, through all the ways damages are calculated and limited, to things like canceling or fixing contracts, court orders, and even rights for the party who breached.
It shows how the law tries to balance compensating the injured party with principles of fairness and practicality.
Yeah, it really does. This dive into Angela's notes should give you a solid framework for thinking about what happens legally when contracts don't go as planned. What part of this really jumps out at you now? Does it spark any new questions?
Maybe thinking about how these rules apply to everyday agreements, not just big corporate deals.
That's a great point. How might these ideas of foreseeability, mitigation, or even rescission play out in, say, hiring a contractor or even just buying something online? That's certainly something worth mulling over.
Hey, this is Angela. I'm back, your living, breathing, not AI podcast host. And I just want to give a thank you to Maud and Claude, our AI bots, who have done this podcast based on my own notes. So, a few things to get out of the way. Number one, AI isn't always correct. Sometimes they're mistakes, and I really try to catch them. Keep in mind, I'm a law student just like you, so I try my best to make the corrections. Number two, I'm not an attorney, and I am not giving legal advice, so none of this should be construed as legal advice. Number three, you want to be safe on the road, so if this podcast is going to cause you to be distracted while you're driving, maybe study for the bar in the airplane or study for the bar at home. Maybe don't listen to it in your car, but hopefully you'll be able to drive and listen to this at the same time. Again, my name's Angela. I'm an LLM law student, graduated from George Mason University. You can reach me at podcast@studyforthebarinyourcar.com. Now, also, I work as an independent law clerk, so I work with attorneys across the USA. So if you are an attorney or you know an attorney who needs some legal help, you can reach me at hello@legalwriterandlawclerk.com. And when I say legal help, this is help writing motions, help writing letters, help writing whatever. I'm a ghostwriter, so often attorneys contact me when they have too much work they have to get done, or sometimes it's work they just don't want to do or can't do or whatever. I mean, I don't really ask the reasons. I just say, hello, work. Anyhow, thank you for listening to this podcast. The next podcast episode is going to be episode 11 on everyone's favorite statute, the statute of frauds. All right. See you on the next episode.